Hi, everyone, and welcome to this week's episode of Law Chats with John and Amy. I'm John Yulian.
And I'm Amy Poliafco. This week's question is, what should I expect at a divorce motion hearing?
Okay, that's a great question. Now, as I'm sure the viewers know, we have already covered different types of motions from our previous podcast. I'm sure they all saw it and loved it. So, we want to talk about a motion hearing and what you can expect. And it might be someone's first experience going to court because in a
Mhm.
divorce case, there can be various types of motions. The most common being, as we've talked about, a motion for temporary orders. We can talk about other types of motions. But as I said, might be your first experience going to court. And one of the things you learn is there will be a lot of waiting. You
It's
need a
a it's
lot
a
of patience.
it's a day of hurry up and wait.
Exactly. And what happens is you go to court, and in some of the counties, they will require, if it's your first time at court for something like temporary orders, that you go to what's called the probation department. And Amy, maybe you can talk a little bit about what happens if you're required to go to the probation department.
Yeah, and so first, a lot of people think probation, like they think of a criminal case and you're out on probation. That's not at all what this is. Remember that divorce hearings are held in the probate and family court. So that's the probate ties to that. Essentially, they are people kind of like mediators to get you to resolve some of your issues. And pretty much every temporary orders, there's something that can be agreed to ahead of time. And the goal of the probation officers is to get you to agree to whatever they can and write up a stipulation. That way, by the time you get down to the courtroom with the judge, they're maybe not dealing with 10 issues, they just have 2 left. So some of the stuff that is easy to deal with is who's going to maintain health insurance. Um, Something like that is generally pretty easy to put into a stipulation. So all the probation officers work a little different in each department. Each county works a little different as well, but generally they get everyone in a room together and they talk through whatever they can, and anything they can get agreed on, they'll put out into a stipulation. One thing to be mindful of is that the probation department will make a note to the judge if one side is being unreasonable, so that the judge has some kind of insight into what happened when you're up in probation. Usually you leave probation and go down to the courtroom, check back in with the court clerk, and the court clerk will then put you in line to talk to the judge. So overall, you rush to get in through the building through security, and then you wait to check in with the clerk. Then you check in with the clerk and they send you to probation, where you check in and then you wait for probation. And then you do probation and then you rush downstairs to check in with the clerk again, and then you wait again for the judge.
Right. And one of the things to remember is when you go to probation, there are other people there that day, other cases. So when you go to probation, it's not like you check in and you say, our case was told to come to probation and we need to meet with a probation officer because you're going to wait while there's other cases being taken. So you can be waiting a significant amount of time. One of the things we often suggest to our clients is if you enjoy reading, bring a magazine with you, a book, whatever you want, because there's going to be a fair amount of time you're sitting and waiting. And then in other counties, plenty of times you can go in for a motion hearing and you're actually going to go before the judge. And so you're going to be waiting in the courtroom for the judge to ultimately get to your case. And during that time, hopefully, your attorney is talking to the other side's attorney, once again, like Amy described, so that they can see what issues can we work out that are in the motion, so that if we had 7 issues that we were addressing at a motion for temporary orders or a motion to compel documents or these other type of motions, that a lot of them can be worked out. So when you go to before the judge, you can say to the judge, we have a stipulation on 5 of these issues, but there's 2 or 3 issues that we couldn't get resolved. Those are the ones we need the judge to address. So, unfortunately, a motion hearing takes a significant amount of time, even though only a short bit of the time will be going before the judge. And if you're fortunate enough to be able to work out all the issues at the motion hearing, then the time will be used to write up what they call a stipulation, basically an agreement on those issues so everybody can sign it. And it can just be presented to the judge as we worked out the issues, and here's the agreement for the judge to sign off on that particular day. Anything else of note, Amy?
I just wanted to kind of explain what the being in the courtroom is like in case this is your first time being in a courtroom. Um, there's a lot of people. We sometimes call it like a cattle call because a judge will have 15 hearings all scheduled for the same time as your hearing. Because some people will be out in the hallway negotiating, some people will be in probation, some people will be ready to present. So the courtroom will generally be pretty busy. You're not allowed to speak in there. But it is pretty interesting. You're going to hear some interesting cases generally. So it's maybe the most, again, like interesting part of the day. And then when your case gets called, you'll go up to the table in front of the judge. They have the two attorneys be in the middle and the parties on either side. Sometimes different counties, there's two tables. In Norfolk County, at least, there's just one table. You'll have to get sworn in by the court security officer, and anytime you're speaking to the judge, you'll need to stand. Generally, for a motion hearing, the only time that you're speaking to the judge is when you are being sworn in, and then your attorney will be presenting their side of the case. The other attorney will get to present their side. And sometimes you get to do a rebuttal or the judge will ask questions. Motion hearings can go anywhere from 3 minutes to 45 minutes, depending on how complicated the issue is and how full the courtroom is, and what kind of questions the judge has for you. And then sometimes you get your decision right then, and other times the judge says they'll take it under advisement, and then your decision gets mailed out to you. So you don't always have an answer at the end of the day.
I think that's great, Amy. I think that's a good place to end for today. Hope everybody has a good week.
Thanks for joining Law Chat with John and Amy. We look forward to chatting with you again next time. If you have a question or comment, feel free to email us at info@ulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.